going to discuss about the salient features of Indian Constitution. And if you observe, the Indian Constitution has so much of uniqueness in itself. Though we have such type of the historical background with the Government of India Act 1935, and we have adapted so many features of Indian Constitution from the Government of India Act 1935, but still if you observe, the Indian Constitution was referred almost all 60 nations constitutions to make its uniqueness. Though we have referred so many nations constitutions, but the Constitution of India has uniqueness in itself. In this video, we are going to see all those unique features what the Indian Constitution has altogether. So let's start. If you see, every written constitution in the world has its own unique characters and no exceptions to the Indian Constitution, but the Indian Constitution has many prominent features that distinguish it from the other constitutions. If you observe, this class completely explains about all those important key features what the Indian Constitution has in its unique self. Let's see. It referred it as the world's lengthiest constitution. Why we call it as the world's lengthiest constitution? Because the Indian Constitution contains the 395 articles and 12 schedules, and making it the world's longest written constitution. And just compare it with the other countries and the constitutions. For example, the UK has no written constitution at all, while the US constitution contain only the 7 articles. That means we have such type of the similarity with the British with the parliamentarian system, but the British has the no written constitution. The British constitution was not referred as written constitution, it is referred as the unwritten constitution. On the other hand, the major provisions we have borrowed from the American Constitution. If you see, the American Constitution contains only the 7 articles, but if you compare the Indian Constitution with the American Constitution, when we have adapted, we have almost 395 articles, and even today with the so many changes of the Constitution and with the addition of the some of the features to the Indian Constitution, we have reached up to 470 articles almost all in the Indian Constitution. And what are the features which made the Indian Constitution this lengthy? We call the Indian Constitution is the lengthiest constitution among the world, and it has such type of the elephantine nature because of its huge size. We refer it as it is having the elephantine size. What are the factors which made it this much of the huge? If you observe, there are the different factors like the geographical factors which had contributed to make the Indian Constitution lengthy. There are so much of the variations in the terrain of the Indian territory, like some are hilly areas, some are the plain areas, and some are forest areas. We have this type of the geographical barriers and such type of geographical challenges. And in the historical sense also, the Government of India Act 1935, from where we have borrowed so many articles, the Government of India Act 1935 itself was a lengthy. That's why in the Indian Constitution we have the so much of lengthiness, and along with that the factors of the social factors. If you observe, when we have adapted the Indian Constitution, the India was under the dominion power of someone else, and the India was suffering from the poor nation, like a poverty conditions are so high here, and along with that, even if you observe, there was a illiterate population and so much of dependables are there on the government. So it is made that much of lengthy constitution. Why? Because the constitution makers want to address each and every section of the people's concerns here, and with these articles, by adding the different parts and the different schedules and the different articles, we are keep on extending, and the constitution was made so lengthy to reach or to satisfy each and every needy persons in the society. So, all these factors made the constitution very lengthy, and along with these all factors, the legal practitioners which were the members of the Constituent Assembly made it as so lengthy. Why? Because they want to give such type of the constitution with a detailed understanding and the interpretation. So, the drafting committee at the time, which was headed by Dr. Ambedkar, made it is very lengthy. Why? Because they want to draft such type of the constitution which is very detailed in understanding, and it should be interpreted very easily. So, all these factors together made the Indian constitution very lengthy. And not only, but since 1951, about 90 articles and more than 100 amendments have been added to the Indian constitution. However, since the articles are not added separately as a part of existing articles, the total number of the articles remain the same at 395 at that time, and presently we have almost all reached to the article number of 470, and all these factors overall made the constitution very lengthy, what we have discussed, and we call that is one of the important unique feature of the Indian constitution. And after this, the next important unique feature of the Indian constitution is it has taken from various sources, and people comment the Indian constitution as the bundle of borrowed constitution. The bundle of borrowed constitution. Why? Because we have borrowed so many features from the different type of the nations, and we have carefully taken such type of the provisions from the different nations and added all those features in our Indian constitution. If you observe, whenever we have borrowed such type of the features from different constitutions, the Constituent Assembly makers at the time, the constitution makers, they commented that whatever the criticism we are facing towards the Indian constitution as a bundle of borrowed constitution, it was not like we have borrowed whatever we like. Accordingly, the requirement of the nation and even the societal demands, we have carefully incorporated the best features of the different nations' constitutions here, but it is not a mere imitation of the other constitutions. Overall, we have taken such type of the feature and we made all those features in connection with the societal needs of the India. So that was the defending thing the constitution makers had at the time, but overall the Indian constitution faced this type of the criticism because it has taken from the different type of sources. Though we have referred so many nations' constitution, but the Indian constitution had the so much of influence from the Government of India Act 1935. So many features has borrowed from the Government of India Act 1935 itself. So let's see what are the different features we have borrowed from the different constitutions. Let's see here. From the Australia, we have borrowed the concurrent list. What is meaning of concurrent list? The concurrent list is nothing but under the 7th schedule of our constitution, we have the 3 different type of the list, like the union list, the state list and the concurrent list. The concurrent list contains such type of the subjects where both the center and the state get the equal powers to make a law over those subjects. That means whatever the matters or whatever the subjects entered under the concurrent list category, all those matters can be allowed to make a law by both the center and the states. That is referred as concurrent list, and that feature we have borrowed from the Australian constitution. And along with that, if you observe the freedom of trade, commerce and intercourse. The freedom of trade, commerce and intercourse, which speaks about the movement of the goods and services from one state to another state within the Indian territory. This type of this trade and the freedom of all that commerce was taken from the Australian constitution, and along with that the joint sitting of the two houses of parliament. What is the importance of this joint sitting? The joint sitting of two houses of parliament says, if in case both the houses failed to pass a bill and any of the house has such type of the disagreement with the other house, like if the Rajya Sabha has a disagreement in the passage with the Lok Sabha and the either way around, at the time if the president feels the passage of that bill is of national importance, then under that condition the joint sitting provision can be called up by the president to break the deadlock of the bill. That means to give such type of the enforcement to the passage of the bill based on the national importance sense, the president calls up for the joint sitting. So this provision of the joint sitting of both the houses of parliament can be called up by the president, and it has borrowed from the Australian constitution. And the next important source is the Canadian constitution, from where the Canadian constitution, which type of the sources has taken. Let's see. The federation with a strong center. What is meaning of federation? We have the federal structure here, that is the complete separation of the powers between the center and the states. And though we have such type of the federation here, again we have the strong center sense here. We have such type of the center's favorism at times in case of the emergencies. The center was provided with such type of the power over the federal structure here. So that feature we have borrowed from the Canadian constitution. Along with that, the vesting of residuary powers in the center. What is meaning of residuary powers? The residuary powers means out of the three lists whatever we have under the 7th schedule, if any of the subjects were not mentioned of these three lists, if it follows or if it falls out of these three lists, then we refer it as a residuary subjects, and the power to make a law over these residuary powers lies in the hands of the center. That means the vesting of the residuary powers lies in the hands of center, and the appointment of state governors by the center. That means if you observe, every state contains the governors, and the appointment of all these governors can be done by the center, that is the president can do so with the advice provided by the council of ministers of the parliament. That means who got such type of the power to appoint the state governors? The president with the advice of the council of ministers in the parliament. And the advisory jurisdiction of Supreme Court. What is the advisory jurisdiction of Supreme Court? We say the Supreme Court enjoys the different type of jurisdictions. Under that, Article 143 says the Supreme Court enjoys the advisory jurisdiction, and whenever the president asks the Supreme Court based on a reason of national importance or any such type of the pre-constitutional agreements litigation matters, under these columns the Supreme Court may render the advice to the President of India, and the link between the President and the Supreme Court in this form of the advice seeking power of the President from the Supreme Court and such type of the mutual understanding of the President and the Supreme Court we refer under the advisory jurisdiction of the Supreme Court. And the Supreme Court only enjoys the advisory jurisdiction. No other courts in the integrated judiciary system enjoys that power. That means the Supreme Court enjoys one extra jurisdiction compared to the other courts here, like the High Court and the subordinate courts, and that advisory jurisdiction of Supreme Court we have borrowed from the Canada. If you observe, just to make you remember for the longer time, if you observe here from the Australian Constitution, the concurrent list where both the center and the state has the equal powers to make a law, and the freedom of trade which talks about the cooperation between the different states, and the joint sitting where both the houses sit together to pass a bill. All these joint cooperation things was borrowed from the Australian Constitution. Just these tips are for the sense of remembrance for the longer period. And if you see here from the Canadian Constitution, whatever we have borrowed the different features, always there is a upper hand in the center. If you observe, we have a federation but with a strong center. That means the center has a more power compared to the states, and the vesting of residuary powers again in the center. That means the giving of the more powers in favor of center, and the appointment of state governors by center. That means again the center's power over the states, and the advisory jurisdiction of the Supreme Court. That means within the judiciary, the Supreme Court is treated as the highest court of appeal. The special jurisdiction the Supreme Court enjoys, that means in the judiciary, the topmost judiciary enjoys the extra power, which is referred as advisory jurisdiction. All these features we have borrowed from the Canadian Constitution. That means the Canadian Constitution always have a favorism towards the unitary features. So from the Canadian Constitution we have borrowed all these features. That means if you observe, just for the understanding sense and just to remember for the longer time, you can decode all these points in this sense. And let's see from the Ireland what we have borrowed. The directive principles of state policy have borrowed from the Ireland. What is meaning of directive principles of state policy? We say it was mentioned under part 4 of the Constitution. Part 4 of the Constitution mentions the directive principles of state policy, and these directive principles of state policy deals all such type of the principles or the ideologies. If the state follows all these directions provided under the directive principles, then the state can make a better law for the welfare of the people. That provision was mentioned under the directive principles of state policy. We have borrowed this feature from the Ireland. And the nomination of members to Rajya Sabha. If you observe, the Rajya Sabha contain both the elected and the nominated members. The 12 members are nominated under the Rajya Sabha by the President. The feature of such type of nomination to the Rajya Sabha was borrowed from the Ireland. Along with that, the method of election of the President. This feature also borrowed from the Ireland. What type of the method we follow for the election of President? We follow the proportional representation by means of single transferable vote. Which type of the method we follow for the presidential election? That is the proportional representation by means of single transferable vote. This is the method we follow for the election of President, and this feature we have borrowed from the Ireland. So from the Ireland we have borrowed all these important features. And let's see from Japan what we have borrowed. We have borrowed from the Japan the procedure established by law. This feature we use under the judicial review corner. We have the judicial review, but our judicial review is based on the procedure established by law. The method of the procedure established by law was borrowed from the Japanese Constitution. Established by law, this provision was borrowed from the Japanese Constitution, and we use the procedure established by law for the judicial review. If you observe, the executive and the legislative actions here can be reviewed by the judiciary. Our judicial review is based on the procedure established by law. That means the judiciary see such type of the review of the legislative and the executive actions, whether those actions are in provisions with the Constitution or the law made by the Constitution or not. So this is the procedure established by law, and we have borrowed that one from the Japanese Constitution. And on the other hand, the provisions of the fundamental duties, which was mentioned under the part 4A of the Constitution, and the ideals of justice under the preamble, whatever we read it as We the people of India, having solemnly resolved to constitute India into the sovereign, socialist, secular, democratic and republic, and to give to all its citizens the justice, liberty, equality and fraternity. The word justice, whatever we read under the preamble, like the social, economic and the political justice was mentioned in the preamble corner, and we borrowed that provision from the Russian constitution. Along with that, from the UK, that is from the British government, we have borrowed the parliamentary form of government. If you observe, we have the parliamentary form of government where we make the executives are responsible to the legislature. That provision we have borrowed from the British constitution. Along with this, from the American constitution, we have borrowed the fundamental rights column, which was mentioned under the part 3 of the constitution. Article 12 to 35 speaks about the fundamental rights, and we have borrowed that provision of fundamental rights from the American constitution. And the independence of judiciary, we have the judiciary independence here, just to avoid such type of the giving of favorable judgments to only few, and to give such type of complete independence for the fair judgments here, the judiciary was provided with the complete independence. Such type of independence we have borrowed from the American constitution. Along with that, we have a judicial review. This judicial review provision also borrowed from the American constitution. And the impeachment of the president. If you observe the impeachment of the president, which is referred as the removal process of the president, that provision also borrowed from the American constitution. Along with that, the removal of the Supreme Court and High Court judges and the post of the vice president. We have borrowed all these features from the American constitution. And the Germany, from the German constitution. The suspension of fundamental rights during emergency was borrowed from the German constitution. That means whenever there is a crisis like situation, whenever the emergency can be proclaimed by the president, the fundamental rights can be suspended. That provision of suspension of fundamental rights during emergency period was borrowed from the German constitution. And from the South Africa, we have borrowed the procedure for amendment in the Indian constitution. That means we have the amendment of the constitution procedures. Our constitution accepts such type of the amendments to be done to the original constitution. Why? Because according to the changes of the society, according to the needs of the people, the constitution can be amended. What is meaning of amendment? It is nothing but the changes you are making to the original constitution. So we have some procedure to be followed regarding to the constitution amendment. Such type of the constitution amendment was borrowed, that procedure was borrowed from the South African constitution. And the election of members of Rajya Sabha, as we discussed, the Rajya Sabha contains both the elected members and the nominated members. And the elected members, the procedure for the Rajya Sabha election was borrowed from the South African constitution, and that was based on the proportional representation by means of single transferable vote, which we refer it as a indirect way of election. So that was borrowed from the South African constitution. And from the France, we have borrowed the word the republic, the meaning of republic, which says the republic means having a elected head. That means just like a American constitution, American government, we have the elected head here who is referred as a president. So that feature we refer it as the republic, and we have borrowed the word of republic from the France. And the ideals of liberty, the equality and the fraternity, whatever the words we see along with the justice in the preamble, like the liberty, equality and the fraternity, all these three was borrowed from the France. So these are the different sources of the reference for the Indian constitution. We have borrowed from all these different constitutions some of the important provisions under the Indian Constitution. And we have to remember the entire table whatever I have given in the slides. Why? Because from this table you can minimum expect one question in the polity question papers. Very oftenly from this corner the question can be touched. So it is very important to remember this table. And we have completed two important features, like it is referred as the world's lengthiest constitution. Along with that, it has taken from various resources. And after that, let's see another important unique feature here. We call it as the federal system with unitary features. What it says? The federal system with unitary features says the Indian Constitution includes all the federal characteristics of governance, like we have the two type of governments, one at the center and the other at the state. That means we have the central government and the state government, and the division of powers between the three state organs, like the executive, the judiciary and the legislature. We have such type of the complete separation of the powers between these three organs. The legislature concentrate on the making a law, and the executive on the implementing of law, and the judiciary to review the legislature and executive actions. So we have the complete such type of separation powers between these three organs, and along with that we have the constitutional supremacy. That means in our political system, in our Indian Constitution, we have the constitutional supremacy here, and the independent judiciary. That means we have such type of the independence to the judiciary. The Supreme Court and the High Court has such type of the complete territorial jurisdictions. That means the boundaries was decided for which type of the court can deal which type of the cases. So we have provided such type of the judiciary. Along with that we have bicameralism. What is meaning of bicameralism? Having two houses, one is lower house and the other is upper house. That means having the lower and the upper houses as a bicameralism. All this together we refer it as a federal systems, the federal characteristics. But we have even some of the unitary features parallelly. That means it's a mixture of both having a federation and the unitary features. Let's see what type of unitary features we have. The Indian Constitution is unique in itself and it contains many unitary features, like we have a strong center. That means under the emergency situations we give so many powers to the center, and we made the center always very much strong here. And all India services which are common to both the center and the states, and the emergency provisions that can transform the constitution into a unitary one. And along with that, the appointment of the governors can be done by the president on the advice of the center. This is also we refer it as one of the unitary feature. That means if you observe under all these conditions, the center has a upper hand over the states. Though we have such type of separation of powers, but still whenever it is required, the center can take a upper hand over the state and it can override the powers given to the state. So that's why we refer it as it is a mixture of both the federation and the unitary feature. And some people even comment the Indian Federation as the quasi-federal or the federation with a strong center. So this type of the criticism was faced by the Indian federal system. Why? Because we have the mixture of both the federation, that is the federal characteristic, and along with the unitary features which gives the power to the center. Why we have taken this type of the uniqueness in the Indian Constitution? Why? Because we say our federation is the unity of the states. We don't provide such type of the destructible sense to the states here. Why? Because the article 1 itself says the India is having the union of the states. Here the states never formed based on an agreement with the center. We never provide such type of the power to secede, that means to move away from the Indian territory to the states. That means we don't allow the states to move out of the Indian territory and to go and have a alliance with the foreign territory. We don't allow such type of the states power here. If any the addition or even the deletion, or that means the seceding of the Indian territory can be done with the foreign territory, that is the exchange of so, then it is the power of the parliament only, that is the center's power. The states does not enjoy such type of the powers here. So though we have a federation, just to avoid all such type of the seceding powers here, and even to maintain the unity and integrity of the nation, we have given the centers more power. And even if you observe, the Indian society has so much of diversification, and our states were divided based on the language basis. So we have such type of the diversity existed here, both on the religious grounds, on the linguistic grounds, and even on the social hierarchies. We have the caste differences, the gender differences. We have so many, so much of diversity, and so many differences existed in the Indian society. So whenever you have given such type of the permission to states to divide or to draw a boundary based on the language basis, then you have to definitely provide the upper hand to the center. Otherwise the states may get such type of the temptation to move out of the Indian territory and to join with their foreign territory where they have a common language sharing, or where they have a common international borders. It's a quite possible. Why? Because they are having somewhere or other way the common grounds to join. So there is a possibility the India may divide again. Already we have seen such type of the division when we underwent the partition. The partition phase was a painful phase for the Indian citizens. Why? Because it has separated the people who were lived like a brothers and sisters earlier, and based on the partition suddenly the people detached emotionally, and even they have detached in so many ways. So it is very difficult again to face such type of the partition phase again one more time. That's why we were very much cautious when we adapted our constitution. Our Indian constitutional makers thought, don't give this much of the complete powers to the states. Of course we apply the federal structure here, but our federation is not a complete federation like the America enjoys. If you observe the American constitution, they have a complete federal powers, the complete federal structure where the states enjoy so much of high power. But we don't have that type of complete autonomy to the states. Whenever it is required, always the center controls the states. That means we give the complete autonomy to the states under the normal circumstances. If they are maintaining a social order and the public order, and if they are not hurting the unity and integrity of the nation, we don't disturb the governance structure of the states. If in case of the failure of any of these conditions, or the failure of the machinery of the state governance process, then the center always provided with such type of the power to control the states. So this is a uniqueness we refer regarding the Indian Federation with the unitary features. And whatever I referred already, the article 1 clearly says it is a federation of the states, nothing but the union of states, and the states did not come together from the center with an agreement, and they don't have such type of power to secede from the Indian territory. And based on such type of the maintenance of the authority, the unitary nature was provided to the federal characteristics. Whatever I have already discussed, all those things were mentioned under the slide. You please go through the slides so that you can read it out and understand in a better format. And let's see the other important feature here. We call it as a parliamentary form of government. What is meaning of parliamentary form of government? If you see, on the pattern of the British parliamentary system of government, the Indian constitution also adapted the parliamentary form of government. And the key characteristics of parliamentary form of government we have here is the executive are members of legislature. We said the legislature is separate, the executive is separate, right? The legislature is a law making body and the executive is a law implementing authority. But in the parliamentary form of government, some of the executive are the members of legislature. How it's possible? How can I say some of the executives are members of legislature here? Here in the central government, we say the president is one of the executive and the president is a part of the Indian parliament. The president is referred as a part of Indian parliament. The prime minister and the council of ministers are referred as executives, and as all we know, they are the legislative members. The prime minister along with the council of ministers and the president, these are the topmost executives. Why? Because without having a assent of the president, no bill can be enforceable in the country. You definitely get the presidential approval, then only whatever the law made by the legislative members, that can be enforceable in the country. Otherwise you can't make the laws implemented in the country. So you have such type of the executives here. That's why we call some of the executives here are part of the legislature. In the same way, within the states also we have a governor who is referred as a part of the state legislature. The chief minister along with the state council of ministers, they are also referred as both the executive and the legislative members. So that is one of the important feature of the parliamentary form of government. And along with that, the collective responsibility to the legislature of the council of ministers. We have a council of ministers, and these council of ministers collectively responsible to the legislature of the council of ministers. That means whatever the council of ministers we have a group of council of ministers. If you observe from both the Lok Sabha and the Rajya Sabha, the members of the parliament we refer overallly, these people are referred as the members of parliament. And out of these members, some are given the ministerial cadres. We call the togetherness of all these ministries as a council called as the council of ministers. And these council of ministers overallly, their actions, they are collectively responsible to the Lok Sabha here. They are responsible, their actions as a council of ministers are overallly responsible to the Lok Sabha. That means the collective responsibility to the legislature of the council of ministers is one of the unique feature of the parliamentary form of government. And we have the rule of the majority party. If we see here, whichever the political party got the majority support, that political party can rule the government, right? So we have the majority party rule here. That means whenever we conduct the elections, whichever the political party gets the majority support, that political party forms the government. So we call this as the rule of the majority party, which is one of the unique feature of the parliamentary form of government. And the next important one is, under the parliamentary form of government, we have the Prime Minister and the Chief Minister leadership here. The Prime Minister and the Chief Minister are acted as a leaders of the states. So that is one of the important feature of parliamentary form of government. And in the parliamentary form of government, the lower house can be subjected to the dissolution. That means the Lok Sabha and the state legislative assembly, they underwent the dissolution process. What is meaning of dissolution? After the expiration of 5 years of term period, automatically the houses underwent the dissolution. At times even before the expiration of time period also, they undergo the dissolution. Why? Because unless and until any political party enjoys the majority support in the houses, then only they can continue the government. Otherwise, the government gets dissolved. So the Lok Sabha overall gets dissolved under that condition, when there was such type of loss of majority to the political party. So this is also, we refer it as one of the unique feature of the parliamentary form of government. And along with that, the government from form of the cabinet, and we have the cabinet system here. Out of the total council of ministers, whatever we have seen, from the member of parliament, few are given the ministries. Together we refer it as the council of ministers. And out of this council of ministers, only few important portfolios, nothing but the ministries, like the finance ministry, the defense ministry, and the external affairs ministry, the space ministry. All these important ministries together form a cabinet system. That means out of the entire council of ministers, the important ministries can be grouped as a cabinet ministers. So we have such type of the parliamentary feature under the Indian political system also. So all these type of parliamentary features we have borrowed from the British Constitution, and we have adapted all these important key features of the parliament. And whatever we have understand the parliamentary form of government, after that let's see, we say it is a balance between the sovereignty of parliament and the judicial supremacy. What is the meaning of this two? We said our parliament is sovereign. What is meaning of sovereign? Sovereign is having the independence meaning. Whenever we say it is independent, then we say it is sovereign. So our parliament is sovereign, and along with that our judiciary is supremacy. How we maintain this type of the balance? Let's see. In our constitution process, we have the three important pillars, like the legislature, the executive, and the judiciary. And there was a complete separation of the powers between these three organs. The parliament is sovereign in itself. That means whenever the parliament make a law, the law is bindable throughout the country, and there is no encroachment of the executives and the judiciary on making a law by the parliament. So it is a complete autonomy provided to the parliament to make a law. In the same way, if you observe, we have adapted the parliamentary features from the British Constitution. Under the British Constitution, whatever we have adapted, if you observe, the British Parliament is very powerful. It never have such type of the judicial review, and there was a comment on the British Parliament which can do anything except changing the men into women and the women into men. That means the British Parliament has that much of powerful functions to be played in the British Constitution. But our Parliament is not sovereign like a British Parliament. Of course, our Parliament is sovereign in itself of making a law, but our Parliament law can be reviewed by a judiciary. That means we maintain that type of the balance. Whatever the law made by a Parliament, it is under the judicial review. That means the judiciary can review the law made by the Parliament, but our judicial review is not like American judicial review. If you observe the previous slides, we have discussed the feature of the judicial review we have borrowed from the American Constitution, right? And our judicial review is not like an American judicial review. Why? Because the American judicial review is based on the due process of law. What is meaning of due process of law? What is meaning of due process of law? That means in the American judicial review, they review the law made by the American presidential system. We don't refer the American as a parliamentarian system. There the Senate is referred as a upper house. So whatever the Senate or even the House of People over there, the houses of the presidential system of America, whatever they made, the judiciary in the American process, they review according to due process of law. What is meaning of due process of law? It is nothing but whatever the law made by the American presidential system, whether that law is justice to the people or not. That means whether the law made by the Senate over there is justiciable to the people or not. So it see what is the consequence of that law over the people. But we don't have that type of judicial review. Our judicial review is having a limitation. It is based on the procedure established by law. That means our judicial review can go for the review of the legislature law only in accordance with the procedure established by law. That means whether this law is in accordance with the procedure mentioned in the Constitution or not. It sees only that much of the review. It won't go beyond of that, and it never go for the review of whether that law is justice to the people or not. We don't have that type of the judicial review, but the American judicial review has that much of the supreme power. So we want to have such type of the balance between the parliament sovereignty and the judicial supremacy here together. So we want to give the parliament the sovereign power and the judicial the review power, but we made such type of the fine lines in the Constitution up to which the parliament can enjoy the independence and up to which the judiciary can review the law made by parliament. So we made this type of the balance between these two so that no organ can enter into the space of the other organ, and we don't have any such type of the encroachments into other spaces. So this type of the fine balance was maintained by the Indian Constitution regarding to the parliament and the judiciary. Important feature is the independent and the integrated judicial structure. If you observe, the Indian judiciary has the uniqueness. It is the integrated and the independent judiciary. What is integrated? If you observe, we have a single judiciary system. That means the Supreme Court at the top. Under that we have the high courts, and under that we have the district courts. So we have some structure which is integrated. That means we have the Supreme Court as the final court of appeal, and we have the high court under that, and the subordinate courts under the high courts. So we have this type of the structure, and whatever the guidelines or whatever the restrictions or any such type of the things the Supreme Court gives, it is bindable on all the other courts. So overall it is a integrated judiciary structure, the single judiciary system we have. But at the same time we have the independent judiciary. What is meaning of independent judiciary? The Supreme Court have a boundary, the territorial jurisdiction over the entire country. That means the Supreme Court verdicts and the judgments are bindable throughout the country. And if the state high court, that verdicts are bindable only on the part of that particular state. And if it is a subordinate court, it has a lesser territorial jurisdiction. So we have such type of the complete difference of powers and the territorial jurisdiction extension to the Supreme Court, High Court and the subordinate courts. And if you observe, we have even provided the independence zone. Why? Because we don't want to interfere the political people, both the legislatures and even the executives, under the judiciary system. Why? Because if you give such type of the interference of the political people under the judiciary, then the judiciary, whatever the judges, they can't give the fair judgments. They will attract to such type of the favorable judgments to the political personalities. Why? Because at one point of time they help them in their career growth. So this is a quite common indication. So we want to avoid all such type of the interference of political people in the judiciary. We want to provide the complete independence to the judicial members in one way or other way, so that the judges can enjoy the independence and they can give the fair and the transparent judgments, and their judgments can have a national importance, and it will change so many factors in the country. If the Supreme Court providing such type of judgments, it has so much of influence over the nations, right? So it is very important to maintain their independence. That's why our constitution has given some of the provisions to maintain the independence of judiciary. Let's see what are the features which give the independence of judiciary. The first and foremost one is the appointment of judges of Supreme Court and High Court. Which way the appointments of these judges can be done? The appointment is based on the collegium system. What is meaning of collegium system? Whenever the Supreme Court and the High Court judges can be appointed by the President get the recommendations of the Chief Justice of India, and in the Chief Justice of India recommendations, it is not a sole opinion of Chief Justice of India. He must get such type of the opinion from 4 senior most judges of Supreme Court. So overall, all these people together, the Chief Justice of India and the 4 senior most judges, together we refer it as a collegium system. That means in the appointment process of the collegium system, we follow the recommendation of the Chief Justice of India, and such type of system includes even the 4 senior most judges of Supreme Court. So it has such type of the collegium system, and through the 99th Amendment Act, in the year 2014, the Parliament, with a Parliament law, they have even tried to interfere in the appointments of the judiciary with the NJAC system. NJAC. What is meaning of NJAC? We call it as the National Judicial Appointments Commission. What is NJAC? National Judicial Appointments Commission. So under that commission, even some of the executives and the social activists along with the judiciary members were made as a part of NJAC, and they recommend the President the Supreme Court and High Court judges' names. So through the 99th Amendment Act 2014, they brought the NJAC with the involvement of the executives in the appointment of the Supreme Court and High Court judges. But later, the Supreme Court made it invalidated the NJAC system based on the ground the involvement of these executives in the appointment process of the Supreme Court and High Court judges may avoid the independence of the judiciary, which itself is a key feature of the Indian Constitution, and the Indian Constitution was stressed out on the point of independence of judiciary. So this type of NJAC may hurt the key feature of the Indian Constitution. So based on these grounds, the Supreme Court made the law made by the Parliament as invalidated. So again, the earlier collegium system only came into the picture. So if you observe, the Chief Justice of India is a judiciary member, and the 4 senior most judges of Supreme Court again a judiciary members. So in the entire process of appointment of Supreme Court judges, all the members who involved in the appointment process are again the judges only. That means the judiciary appointments can be done by only the judiciary members. So it is a one sort of independence without having any political influence on their appointment. The next one is the removal of judges in parliament through a impeachment procedure. Yeah, the parliament has a right to remove the Supreme Court and High Court judges. Maybe you get a doubt, if the parliament was provided such type of power, then it is not called a independence of judiciary. But though we have given such type of power to the parliament, but we made the procedure as impeachment, which is very difficult. You can't easily remove the Supreme Court and High Court judges. It is very tough process. That's why we refer it as impeachment. In our entire Indian polity, the removal of the president and the Supreme Court and High Court judges removal are referred as the impeachment procedures. Nowhere you see the impeachment procedure. So we have given that much of the tough procedure to get removed the Supreme Court and High Court judges. Let's see what such type of procedure we have. Just for your understanding, I will give you a few minutes what is the removal process, so that you see how difficult it is to remove a candidates. The bill can be introduced in either houses of parliament, that is either Lok Sabha or in the Rajya Sabha you can introduce a bill. And if you are introducing a bill in the Lok Sabha, you need minimum 100 members support. I am talking about it is for the introduction itself. Just to introduce the bill, you require minimum 100 members support under the Lok Sabha. And if you are introducing the same in the Rajya Sabha, you need the 50 members support. And you have the inquiry commission, and the Supreme Court and High Court judges can be removed only on the grounds of proved misbehavior, and incapacity. Only on these grounds only you can remove the Supreme Court and High Court judges, not in any other grounds. So the proved misbehavior and incapacity is referred as grounds for removal. So the inquiry commission must prove the person is suffering from this type of proved misbehavior and incapacity. And this inquiry commission again contains the 3 members. Try to understand the removal process. The 3 members, and these 3 members are nothing but the Chief Justice of India or the senior most judge of Supreme Court, and one more member, the Chief Justice of concerned state high courts. The other member we call the distinguished jurist. Who is distinguished jurist? Nothing but any judge or any lawyer, the case whatever they have taken up, the judgments whatever they have given, it was having a national importance, and the judgment they have passed, it changed so much of important things in the country. So at the time the president recognized their talent and they were called as the distinguished jurist. And it is in the opinion of the president only. Who will give such type of distinguished jurist position? That is by the President of India. And all these 3 members gets involved in the inquiry commission. That means if you observe, who are conducting the inquiry? Again all the judiciary members only. Though the parliament can initiate the bill, but still the inquiry can be done by these members only. And the inquiry commission must prove that that person is having a problem of all this and he is suffering from the grounds whatever mentioned under the Indian Constitution, then only the bill can be placed for the passage in the houses. That means once the inquiry commission, which contain all the judiciary members, if they prove so, then only the bill can be placed for the passage. And under the passage you require the special majority. What is special majority? it is very tough to get the special majority. Why? Because you require so much of high majority, the 2/3 of the members present and voting and the majority of total membership of house. You require that much of highest majority to pass a bill. Don't panic to understand this majority right now. I will explain you in the constitutional amendment process the different type of majorities. At the time you can understand what is special majority. So as of now, you please remember, it required the special majority, and in the both the houses the bill must be passed with a special majority. Then on that particular day, the parliament recommend to the president, the council of ministers recommend to the president, sir, this person was proved that he was suffering from these grounds, and both the houses also pass the bill with the special majority. Then on that particular day onwards, the Supreme Court and High Court judges can be removed by the president. So if you observe the toughness of the removal process of the Supreme Court and High Court judges, then we can understand how difficult it is to remove the candidate. So this much of the independence was provided to the Supreme Court and High Court judges. They can't remove that easily. It is a very lengthy process. We refer it as a impeachment procedure to be followed. And along with that, the Supreme Court judges' salaries, the pensions and the allowances are charged out of the consolidated fund. That means from the consolidated fund of India, the salaries, the pensions and the allowances of the Supreme Court judges can be charged. What is meaning of this? There are different type of the funds the Indian government maintains. The consolidated fund is referred as the one of the important fund. Out of this consolidated fund, the amount can be withdrawn once within the appropriation can be done, then the amount can be withdrawn from the consolidated fund of India without having the legislature passage requirement every time. So the amount of these salaries and allowances can be withdrawn from this fund, so that you don't need to be bothered about the passage of bill every time in the house. So that type of independence was provided, and the power to punish for self-disregard, that means the judiciary is referred as a self-correcting body. That means whatever the verdict the Supreme Court judges has given, they recorrect that one. That means maybe earlier they have interpreted the constitution in a narrower sense, and later they interpreted the constitution in a wider perspective. So this type of the self-correction is always a possibility to the Supreme Court and High Court. So the power to punish such type of the self-disregard is not there. So we don't have such type of power to punish them. And the ban on judges practice after retirement. So you can't allow for the private practices of the Supreme Court and High Court judges after retirement. And if in case any pending of the cases are there to the court so high, along with that, if the court is having such type of lack of numbers of judges, under these conditions, after retirement also, the Chief Justice of India get the power to ask them again to take a charge as the Supreme Court and High Court judges. He can do so with the recommendations of the President. That means the President must be informed prior with such type of the reappointment of the retirement candidates. Otherwise, unless until the Chief Justice of India asks for their service in case of this type of the huge burden on the courts, otherwise he was not allowed to practice privately anywhere in the country. So this is one of the independence of judiciary feature we say. Why? Because if you allow such type of private practice, maybe after retirement also they want to continue that profession. So when they are having such type of dignitary position, they can give some favorable judgments to others, so that they will engage them after their retirement in the different cases. So this is a possibility just to avoid all this handling of misuse of power. we have given such type of ban on practice after retirement. Only the retired candidate can be reappointed by the Chief Justice of India with a prior permission of the President. So that is only a possibility, otherwise they are completely banned on the practice after retirement. So in this way, whatever we have discussed, we were provided the independence to judiciary. So overallly, one of the unique feature we say the Indian Constitution has is it had the integrated and the independence of judiciary. And the next important unique feature is it was a combination of rigidity and flexibility. The combination of rigidity and flexibility. We said there was a amendment procedure to the Constitution. That means according to the needs of the society, the Constitution can be amended from one phase to another phase. That means the Constitution can be changed, but the changing of this Constitution is not that easy. Some of the provisions of the Constitution can be amended with a simple majority, and some are very tough to amend it. Why? Because it requires the special majority, and at times the special majority with half of the consent of the states also. So let's see why we say it is a combination of the flexible and the rigidity characteristics. To understand this one, I want to give some of the clarity here. First of all, what is these majorities? Why I refer it as flexible and why I refer even it as the rigid? Let's see. The Article 368 of the Constitution deals about the amendment of the Constitution. And under the Article 368, whenever you are amending the Constitution, it requires the two types of majorities. One is called as special majority. Try to understand the majorities here only, so that in the next videos, whenever you see it requires this much of majority support, then automatically you have to understand, okay, this is the majority required for that process, whatever, whether it is a removal process of speaker, whether it is amendment of Constitution, wherever I am referring the different type of majorities required, you can able to connect your mind to this class. So please try to understand the special majority. What is meaning of special majority? And first I write the two types. The special majority with half of consent of states. What is the meaning of this one? Let's see. Let's see what this majority speaks about. First of all, what is special majority? The special majority is nothing but the 2/3 of members present and voting and majority of total membership of House. It says the 2/3 of members present and voting and the majority of total membership of House. You need this much of the majority for the special majority criteria. So first of all, what is the present and voting and what is total membership difference? Out of the total membership, that is the maximum strength of the Lok Sabha based on today's digits is 550. Why? Because the two nominated candidates of the Anglo-Indian community is no more existed right now. So that's why I changed 550 here. Maybe in the books you read it as 552, but please make a correction. Why? Because very recently the Anglo-Indian community representation was discontinued in the Lok Sabha. So the 550, suppose, and in the Rajya Sabha you have 250, and this I refer it as the total membership. Out of this 250, if suppose on that particular day only the 180 members are present, and these 180 members I refer it as the present and voting, and this I refer it as the total membership. So for the special majority, I require the 2/3 of the members present and voting and the majority of total membership of house. What is the majority of total membership of house? That is half plus 1. That is, if the total strength is 250, I require 250 by 2 plus 1. So I require this much of the majority for the total membership of the house majority. So out of this 2/3, that is 180 into 2 by 3rd, I require 120. So I need to get these two majorities, then only I can able to pass the bill. So this is about the special majority. That means the 2/3 of members present and voting and the majority of total membership of the house. So I require all this together and then only the bill can be passed. This is very difficult to get these two majorities together. So that's why we refer it as very rigid to change some things. That means under the Article 368, if I want to change some things, then it is very difficult. Why? Because I have to pass that bill with this much of high majority. That's why I refer it as very tough to pass. On the other hand, some require the special majority with the consent of half of states. What is meaning of consent of half of states? That means within the state legislatures, you have to place the bill. After the parliament has passed the bill with a special majority, the same bill can be introduced in the different state governments, and out of these state governments, half of the states, whatever the total strength you have the states, out of that half of the states must pass that bill, but within the states you require only simple majority. So that is referred as the consent of half of states is required. So wherever the federal structure gets disturbed, if whatever you have incorporated the changes in the Indian Constitution amendment, if it disturbs the federal structure, maybe like the example of you are changing the election procedure of the president, which involves the state legislative members under that in the election process, or if you are disturbing the 3 lists mentioned under the 7th schedule, which give the complete separation of the powers between the center, state and the concurrent list. If you are changing any of these 3 lists, definitely it hurts the state's interest. Why? Because you are transferring some of the powers of the state in the hands of the center. So whenever this type of the federal structure gets disturbed, at the time you require the consent of half of states also along with the special majority. So this is very difficult to get. The goods and service tax was amended based on this majority. That means whatever we are seeing today, the indirect way of taxation structure under the goods and service tax procedure, it was amended the constitution with this much of the majority, which was very difficult to get. So if you observe, the Article 368 says if you want to change some things under the constitution, you require special majority and the special majority with half of the consent of states, which is very difficult to get as a majority support. And on the other hand, some require only simple majority. That means out of the purview of Article 368, that is out of Article 368. If you want to change some things, you require only the simple majority. What is meaning of this simple majority? This is nothing but, if you want to change something, you require only the majority of present and voting. That means on that particular day, how many members are present, out of that, if you can able to get the majority support, then you can pass a bill. That means, suppose out of this 250 of Rajya Sabha, if on that particular day only 150 members are present, there is a minimum strength required to conduct a session. We call it as quorum. The minimum strength required to conduct a session. What is the quorum? That is 1/10 of the total strength. In the Rajya Sabha, we take it as 25. In the Lok Sabha, we take it as 55. That means, unless and until the Rajya Sabha contains the 25 members, you can't conduct the session. If the Lok Sabha does not contain 55 members on the particular day as attendance, you can't conduct the session. So, once they get this much of numbers, after that you can conduct a session. So, I am roughly taking the 150 as attendance. So, what is majority? Always consider the majority is half plus 1. On that particular day, how many members are there? 150. So, half plus 1 is the 75 plus 1. I require the 76 member strength to get the support. This is very simple to get. How many members are present? Out of that, I got the half plus 1, the majority required. So, this is very simple to pass a bill. So, in this way also, out of the purview of Article 368, the constitution can be amended. So, overallly, if you observe, at times we are saying it is very easy to change some things under the constitutions, and in the same way we are saying some are very difficult to change also. So, it is a combination of two. If you observe, some are, we say it is the special majority with the consent of half of states. It is very difficult to get, that is why I refer it as rigid in nature. And some require only simple majority, which is very easy. So, that is why we say it is a combination of rigidity and the flexibility. So, this is all about the combination of rigidity and flexibility. And here only I want to give one more extra point. It is not relating to the amendment of constitution, but in your polity classes you even see, I will write it in a separate slide so that you won't get confused. For some of the positions you require even the absolute majority. What is meaning of absolute majority? But please remember, it is not to the constitution amendment, it is separate. And for the removal of the speaker removal, the removal of the vice president, the removal of deputy chairman of Rajya Sabha, and the removal of deputy speaker of Lok Sabha. All these you require the absolute majority. What is meaning of absolute majority? This is the majority of total membership of house. That means if it is a Rajya Sabha, then I take it as 250 by 2 plus 1, the total membership, and if it is a Lok Sabha, I take 550 by 2 plus 1. This is the total strength of Lok Sabha. That means if it is a absolute majority, remember it is calculate the majority based on the total membership of the house. So, this type of the majority also is there in the constitution process, but the absolute majority is not applicable to the constitution amendment. The constitution